Hi, my name is Samantha Broadfoot and I'm a barrister at Landmark Chambers.
I'm Toby Fisher. I'm a public law barrister at Landmark and I've been here for about 9 years.
I'm Leon Glenster. I'm a public law barrister here at Landmark Chambers. So public law is the challenge of any government body's decision. So that may be challenging the abortion laws in Northern Ireland, it may be challenging how the government deploys Article 50, or it may be challenging the bedroom tax policies of the government, and all of those are cases which Landmark public law barristers have acted in over the last 12 months or so. Landmark is fairly well placed in the public law market because it acts and is known for acting for both claimants and defendants. So you get to experience practice on both sides of the coin, defending decisions and challenging decisions. It dovetails well with the other areas that Landmark practices in. In planning, a lot of decisions are local authority decisions which you're challenging on judicial review principles, so it is essentially a subset of public law. There's also a big overlap with property as well. I, for example, do a lot of housing work, which is by definition a mix of public and property.
It's about rights and powers. So it might be about the extent of powers held by a public body and who has those powers and what are the limits on them. But it's also about the rights of the individual and what are the limits on those rights. And where you have a tension between the powers and the rights and how that tension is resolved is what determines the kind of society that we live in.
Public law is unique because what holds it together as an area of law isn't the substance of the decisions that are being taken, it's the decision maker. So public law is held together because the decision maker in all areas of public law is a public authority. In public law, the substance is wide-ranging and diverse. It is essentially any decision that a public authority might make. So that could range from a very ordinary decision about who can build an extension on the rear of their property, through to whether you can detain someone without trial for 5 years. What's unique is the diversity of substance, because what's holding it together is the decision maker.
Public law is topical, it's challenging government policy. Public law, as compared with other areas of law, often involves smaller cases but more of them. So you rarely are doing a 3-week trial, which you may be in a commercial setting. So it means that you get responsibility and court appearances yourself at a much earlier stage. Analytical skills are key in public law because you are challenging decisions on points of law only. In judicial review, you don't have witness handling, you don't have cross-examination, which means it all rests on oral submissions. So having the analytical skills to build an argument and then deliver that argument in court are very important.
The ability to empathise with the people that you're working with is probably very important, and an inquiring mind and a genuine interest in the law also is a good quality to have.
What makes a great public law barrister is someone who is engaged with and interested in the way in which public authorities make decisions and the way in which the state interacts with the individual. The highs and lows of practice, well, like football managers, we're in the results business. So the highs are the wins, the lows are the losses. And although as a barrister you're able to persuade yourself sometimes when you lose that you advise the client of the low prospects of success, it's never quite enough to undermine the disappointment you may have in a loss. And that's partly because in a public law context, the wins and the losses really matter. This is about individuals and community groups and the way they live their lives and the way in which governments can regulate the way they live their lives. So a loss can mean that your client is deported from the country. It can mean that your community group has to endure ongoing pollution, both noise pollution and air pollution. And it can mean that a commercial client loses their livelihood. On the flip side, when you're able to assist your client to get the victory, to get the win that they want and the result they want, knowledge that you've been a core part of that success can be hugely rewarding and satisfying. So one of my latest cases, I'm representing the exiled opposition leader of an African state in his asylum claim in the United Kingdom. It's a complicated case because he's been in the United Kingdom for 6 years awaiting a lawful determination on his claim. There have been 3 previous unlawful decisions taken by the Secretary of State, and a recent 4th decision has been taken, which we're currently appealing. His objective, of course, is to get asylum in the United Kingdom so that he's not returned to his country of origin where he says he would be at real risk. The evidence suggests it's quite clear that he would be at real risk, but the Secretary of State is currently suggesting that he may be excludable under Article 1F of the Refugee Convention as a war criminal. We, of course, say that's not the case. It's a hugely interesting case, and it involves not only questions of asylum law in the domestic context, but also European asylum law, because he has been in other European countries over the past few years.
I'm currently involved in litigation in the sovereign bases areas in Cyprus, which is a British overseas territory and has its own legal system and its own judges. There's a large challenge being brought by about 1,500 claimants to an ordinance, which is a legislative act by the administrator to cut wages by a certain percentage. My role in this litigation, in addition to dealing with the actual challenge that is being brought by way of judicial review, is to devise a strategy how to manage the litigation. So how do you have to identify the issues from the outset and work out who might need to provide evidence. You need a system for ensuring that you comply with your duty of candour and that you maintain and keep relevant records. You need to advise on evidence. And then there are other practical issues such as the sheer number of claimants and the individual circumstances that arise, the fact that they're represented in different groups by different lawyers with different approaches, all means that your role is in fact quite multifaceted and is far broader than just answering the pleadings or drafting the skeleton argument.
An example of a recent case I did on my own without a QC leading me was a challenge to a well-known art school's decision to withdraw a sixth form place of a boy in year 11 on behaviour grounds. It was interesting because we're in uncharted territory. This was a city technology college, of which there's only one in the UK, and therefore questions like whether government policy applies to that school or not were new questions, and so we were creating new arguments.
So in the case that I was discussing earlier about the asylum application from the exiled leader of an opposition African country, how do I spend my days? They're very mixed. It would be lovely in practice if you were able to spend your days exclusively on the one case. It tends to be the case that there are many cases floating around at the same time and you're juggling all of them at the same time. But on that particular case, the case begins with instructions. You need to provide initial advice in writing. You might have a conference to follow up that written advice. Following on from that, drafting grounds of appeal to the Court of Appeal, subsequently receiving grounds from the other side or a skeleton argument for the other side, drafting a skeleton argument, and then subsequently representing the client in the hearing in the Court of Appeal.
The great thing about public law is that loads of cases are interesting, and indeed most cases have something interesting about them, and I think it's almost impossible to pick just one. But in recent years I was involved in a series of cases which challenged the compatibility of various provisions of the Human Embryology and Fertilisation Act with the Human Rights Act. And it arose in a variety of ways, but one of the cases that I particularly remember and was absolutely fascinating was one in which the mother of a child brought a challenge against the state's refusal to include the father's name on the child's birth certificate in circumstances where the child had been conceived by artificial insemination posthumously, so after the father had died, but without his prior written consent, which is a requirement of our legislative scheme. So the case was fascinating because it required you to understand why Parliament had set out the scheme that it had, which in fact had been hotly debated, and also to consider comparative jurisdictions and other countries. What are their schemes for the recognition of children born in those circumstances? Because that affects the arguments that you can run in relation to defending or attacking, depending which side you are on, this type of challenge.
My most interesting work's probably in the context of public inquiries. I have a specialty in public inquiries, and I was junior counsel to the Leveson inquiry into press ethics, and subsequently represented the South African Human Rights Commission in South Africa in an inquiry into a police shooting in Marikana, South Africa, where 34 miners were shot dead at a strike in August 2012. That's probably my most interesting piece of work. It was an inquiry that went on for 2 years and involved both an investigation into the conduct of police on a particular afternoon when the 34 miners were killed, but also a more broad inquiry into the way in which the mining sector had been regulated and both the communities around the mines and the workers in the mines had been treated over a number of years.
These days, most applications will have stellar academics, so that's no longer a differentiating factor. So it's all the more important students now will do things that are over and above their studies. One thing that's an obvious way to deal with that is by volunteering. So in the education context, there's a charity called IPSIA, and you can represent parents, even if you aren't a qualified barrister, represent parents at tribunal hearings. Or the Free Representation Unit, where you can deal with benefits cases on behalf of individuals. Another way of improving your CV is by writing. So before I became a barrister, I ran a legal blog. You may be writing your own blog, or you may be writing for other blogs, or writing for publications generally. It's a way to differentiate yourself from the other applicants. I'd always say doing a mini pupillage is very important in the public law sphere. So make sure you've done one mini pupillage at a public law chambers. It is beneficial to have done it at Landmark because you can see the building, you can meet the barristers, but it's not absolutely crucial it must be Landmark, but I'll do at least one mini pupillage in the public law sphere.
So to prepare for a career in public law, the prerequisite, of course, is to work hard, get good grades. But more than that, you need to demonstrate that you have a real interest and passion for those elements of public law that will drive you through your career. So demonstrate an interest in policy, in public policy making, and the way in which public authorities make their decisions. Volunteer where you can at an NGO. See if you can get an internship at an organisation that engages with policy making. The Bingham Centre, the Constitution Society, volunteer at FRU. These are the kinds of things which will help you demonstrate an interest in public law, but also help you develop an understanding of the kinds of things which matter in decision making.
Well, a good thing to do to prepare for a public law career at Landmark Chambers is to get into the habit of regularly reading the public law blogs that are freely available. And one way to try and stay on top of that is to follow a range of public law blogs or public lawyers on Twitter. And there are huge numbers of these. I mean, apart from the obvious ones like the Ayres Centre and the Bingham Centre and the UK Supreme Court, there are individuals who post links to many interesting articles that will help you, I think, be a more rounded public law in the future, such as Henry Brooke, Adam Wagner, Colin Yeo. There's a massive range of people, and Paul Daly, and once you start following a few, you'll end up with suggestions of other people to follow, and that, I think, would be quite helpful.